Lochner v. New York is the ultimate mistake in American constitutional law. Decided in 1905, it is universally taught as the supreme example of judicial overreach, a case securely locked in the anti-canon. Legal scholars and Supreme Court justices agree the decision was wrong, yet they remain locked in a century-long dispute over exactly how it was wrong. The dispute circles a single invisible concept, the baseline. In Lochner, the court treated the unregulated free market not as a legal construct invented by humans, but as a state of nature, a neutral zero point against which all government action had to be weighed. If the market is natural, any regulation becomes a deviation that the state must strictly justify. The scale appears to weigh liberty against state power fairly, but the choice of where to place the fulcrum determines the outcome before the weighing even begins. The true danger of Lochner is how it smuggled a highly contested economic theory directly into the Constitution, protecting it by pretending the legal choice was completely objective. The conflict began in February 1902, inside Joseph Lochner's bakery in Utica, New York. Urban bread bakeries of this era were labor-intensive, small-scale operations, often located in the cellars of tenement houses with dirt floors. Lochner allowed an employee named Amen to work more than 10 hours a day and 60 hours a week. This directly violated Section 110 of the newly passed New York Bakeshop Act. Because it was his second offense, Lochner was convicted in a county court and fined $50. The Bakeshop Act was drafted as a sweeping sanitary regulation. Progressive reformers noted the poor ventilation and grueling hours, arguing the law was necessary to protect the physical well-being of workers and the public consuming their bread. But the law had another major constituency. It was heavily backed by the bakers' union. To critics, the hours cap was an opportunistic cartel mechanism. By forcing compliance with strict hours, larger unionized bakeries could squeeze out small, non-union immigrant shops like Lochner's. The courts had to resolve a precise dilemma. Was the Bakeshop Act a legitimate public health necessity or a union-backed manipulation of the labor market? Lochner demurred, conceding the facts but arguing the statute was unconstitutional. The county court overruled him. At the appellate division, his conviction was upheld, with 2 of 5 judges dissenting. The state's highest court also affirmed, 4-3. At every level, the judiciary fractured. Lochner filed a writ of error to the United States Supreme Court. On April 17, 1905, by a bare majority of 5-4, the court overturned the conviction and struck down the New York law. Justice Rufus Peckham authored the majority opinion. Peckham grounded his logic in substantive due process, the doctrine that the 14th Amendment's protection of liberty includes certain unwritten rights. Chief among them, Peckham declared, is liberty of contract, the freedom of an employer and employee to agree on the terms of labor. He acknowledged this liberty is not absolute. States possess police power, the authority to restrict individual rights to protect public health, safety, and morals. To navigate this collision, Peckham established a legal test. The court must ask whether a regulation is a fair, reasonable, and appropriate exercise of the police power or an unreasonable, unnecessary, and arbitrary interference with individual liberty. Applying this test, Peckham noted that bakers are sui juris, competent adults of full legal capacity. They are not wards of the state. He concluded that baking is not inherently dangerous enough to justify state protection, declaring the hours cap a pure labor law, not a legitimate health measure. By striking down the law, Peckham enshrined the free, unregulated labor bargain as the natural baseline of the American constitutional order. The inequality of bargaining power between a journeyman baker and a boss baker was treated simply as nature. 3 justices dissented, led by Justice John Marshall Harlan. Harlan did not reject the concept of liberty of contract. He accepted Peckham's legal framework entirely, but argued the majority had misapplied its own test by refusing to defer to the legislature. Harlan insisted on a strict burden of proof. A legislative act must stand, he wrote, unless it is plainly and palpably beyond all question in excess of legislative power. If the necessity of a law is debatable, the courts must uphold it. To prove the health risks were debatable, Harlan introduced empirical medical evidence. He cited treatises detailing the inhalation of flour dust, grueling night shifts in overheated rooms, and data showing the average lifespan of a baker was significantly shorter than other craftsmen. Harlan fought a valiant evidence-based battle to add weight to the state's side of the equation. Yet, by accepting the majority's premise, he failed to question why the scale was built to favor the unregulated market in the first place. It was Justice Oliver Wendell Holmes, writing a solo dissent, who refused to play by the majority's rules. The 14th Amendment does not enact Mr. Herbert Spencer's social statics. Herbert Spencer was the era's leading philosopher of social Darwinism and laissez-faire economics, the theory that government must leave markets completely alone. Holmes explicitly accused the majority of treating this specific, highly contested ideology as the supreme law of the land. Holmes pointed out that the Constitution is not neutral toward markets. The law already restricts contracts everywhere. Sunday closing laws, anti-lottery statutes, and usury regulations all dictate economic terms. The market is not a state of nature, it is a legal construct. He offered an alternative test. A statute should be upheld unless a rational person would necessarily admit it violates the fundamental traditions of American law. Since reasonable people clearly viewed the hours cap as a sensible health measure, the inquiry should end there. Holmes demonstrated that there is no neutral, theory-free baseline. By setting the fulcrum at the unregulated market and calling it nature, the majority was making a partisan theoretical choice and disguising it as objective legal truth. Over a century later, Lochner remains the touchstone of judicial error, yet the precise nature of that error continues to divide legal scholars. Legal scholar Cass Sunstein argues the primary error was exactly what Holmes identified, the baseline problem. The court mistakenly treated common law market ordering as nature rather than a legal construct, rendering any redistributive policy constitutionally suspect. Conversely, David E. Bernstein argues the court was correct to protect fundamental liberties against arbitrary, union-backed cartel legislation designed to stifle competition. Historian Paul Kenz frames it as democratic usurpation, arguing the court overstepped its bounds to force a laissez-faire philosophy onto a public that had voted for reform. This debate extends far beyond historical trivia. It is an active, high-stakes battle over how courts view and justify their own power when reviewing economic and social legislation. The ghost of Lochner appears every time a modern court must decide if the government has actively intervened or merely declined to act. To define government inaction, a judge must first set a baseline of what is normal, and as Holmes observed, that choice of baseline is never truly neutral. When the state does nothing, it is still making a choice. Believing that a lack of regulation equals a lack of legal architecture remains constitutional law's most persistent and dangerous illusion.